Good afternoon, everybody. It's a great pleasure to be here today. My greetings to my colleagues and everyone present here. Warm welcome to you all, and especially to Michael Davis. I would like to highlight the importance of and the significance of this event. More than ever, we need to reinforce cooperation between universities around the world, especially in an international context marked by erratic and authoritarian behaviors that isolate countries in terms of trade, in terms of politics, and also academic exchange. The partnership we have with the University of Technology, Sydney, is extremely important for our graduate program in law here at the Federal University of Minas Gerais. And the event today, I think, is a proof of the success of this initiative. And I personally hope that this will grow and deepen in the coming years. We are pleased to welcome here Professor Michael Davis. And I would like to briefly introduce him. Michael Davis is Research Fellow at the UTS Centre for Media Transition, where he leads the Information Integrity Research Program. His current research focuses on the impact of generative AI on news and the digital information ecosystem, regulatory responses to misinformation, and epistemology of the online public sphere. Prior to UTS, he was Senior Policy Advisor at the Australian Communications and Media Authority, where he worked on misinformation, the news, media, bargaining code, and impartiality in news. Michael Davis has a PhD in philosophy in Australian National University in Canberra, and he taught philosophy and the history of ideas at the Australian National University and the Universidad de los Andes in Bogota, Colombia, and media law and ethics at the University of Sydney and UTS. He is a member of the Tech and IP Law Research Cluster and the UTS AI and Data Ethics Cluster, and currently teaches Disruptive Technologies and the law. That's it. Okay, the subject of Professor Michael Davis' presentation today is legal landscape for digital platform regulation and measures to counter misinformation in Australia. The Australian experience in this area is very interesting, and I'm sure we have a lot to learn with the Australian experience and with this exchange of ideas and backgrounds. Please, the words is yours. Thank you very much. Great.
Thanks very much, Marco, for that kind introduction. I would also say that it's fantastic to have the opportunity to be here, and I would thank you for the invitation and Marco for looking after me, and Emilio as well, and setting things in place for me to be here. It's the second year of the exchange, and I hope that we'll be able to keep it going in the future. So I guess Australia has, a few interesting pieces of legislation and regulation in the digital platform space that have both, inspired regulation elsewhere and in some cases also provided examples of failure. And I'll speak about one of those today. And for us, Brazil is also very interesting in terms of, how it's moving forward with digital platform regulation, particularly through the Supreme Court and judicial decisions. That is something that we don't really have in Australia. We have very poor protections for rights and human rights, mostly we're proceeding through legislation and regulation and in fits and starts, really. And I'll try to give a picture of that today. All right, so to begin with, I'm just going to talk about the general landscape of digital platform regulation in Australia and a few adjacent areas of law like privacy, defamation, and so on, which all come together to impact this space of digital platforms. And yeah, then I'll have a longer look at misinformation regulation. That's my main area of focus, and I'll talk about a paper that I published this year on Australia's failed misinformation bill and where I see it going wrong, and then talk a little bit about where we hope the government goes, in any case, with regulation in the future. Right. So first of all, I guess the main thing to note about digital platform regulation in Australia is it's very fragmented. There's a large number of different pieces of legislation that focus on different areas of content or different online harms, and there's a real lack of coherence in the regulatory system for that reason. So over successive governments from both left and right, when I say left and right in Australia, they're both parties are fairly central. But there's been a kind of reluctance to push forward with really significant reforms, except for a few particular areas. The main areas of focus are online safety and harmful content, and that's really the area where Australia has pushed forward. In competition and consumer harms, we've got one piece of legislation there, the News Media Bargaining Code, which has proved a model for legislation elsewhere. There's also privacy and data protection, where I would say leagues behind other countries, and protections for information integrity, misinformation, social political harms. We're certainly well behind some other countries, jurisdictions such as the EU, the UK, and so on. All right, so I'm just going to talk about these different areas, if you like, just to give you a picture of what's happened, broad timeline of the different pieces of regulation here. Should I move that further now? There we go. All right, so online safety, the first area. This was really the first area where we moved ahead in Australia on digital platform regulation. And by online safety, I mean harmful content, illegal content, child sexual abuse material, violent material, terrorist material, and then expanding from those areas. So the first scheme was in 1999 when a schedule was attached to the Broadcasting Services Act, which is from 1992, which is the main piece of legislation that regulates television and radio broadcasting and other kinds of broadcasting in Australia. And that set in place a content takedown scheme for illegal content. And that chucked along. There was a code of practice established in 2007 for 2005 for that Schedule 5 that was spelled out, I guess, the obligations on digital platforms for takedown of illegal content. But it wasn't until 2015, 16 years later, that the eSafety Commission was established. And I think the eSafety Commissioner is reasonably well known around the world now. And that was one of the first pieces of legislation, establishing a dedicated regulator for online safety. And so the eSafety Commissioner at that time, and actually still sits under the Australian Communications and Media Authority, where I used to work, and is kind of a sub-commission under that. They're kind of independent, but the funding is tied to the same funding body. So that established a commissioner who would then they both conduct research, they do consumer education on online harms and how to be safe. And the particular focus in 2015 was on children's online safety. So they introduced a cyberbullying scheme, to try to manage online bullying of children, and as well as the illegal content takedown scheme that continued. In 2018, the scope of the Commissioner's powers were expanded, and that started to move towards a broader segment of society, including adults, right? So the focus started to move away from children's online safety. So there's the adult cyber abuse scheme, and they introduced image-based abuse regulation, or what's commonly known as revenge porn, where you can make a complaint to have non-consensually shared material taken down from platforms. So this sort of suite of powers operates with a complaints mechanism, same as the online content, illegal content takedown scheme. And so the Commissioner is notified, the content gets assessed according to their criteria, and then the notification is passed on to the platforms to take down the content. In the case of illegal content, the police are also notified. In 2019, the government introduced the Abhorrent Violent Material Act. This was an amendment to the Criminal Code, and that followed the Christchurch mosque massacres in 2018, which was where an Australian went to Christchurch, which is in New Zealand, and with the automatic machine gun killed, I think, 50 worshippers at a mosque in Christchurch, and live streamed the whole event onto Facebook. So there's a criminal code amendment. So it became a criminal offence to live stream violent content. And there's also, again, a takedown scheme and obligations placed on platforms to take down that content. And also obligations placed on broadcasters to not to broadcast live streamed abhorrently violent acts. In July 2021, the Online Safety Act was enacted, which established the separate, really expanded the e-safety Commissioner's remit, kind of made the e-Commissioner a bit more independent from the Communications and Media Authority, and started to move towards what you might say is a systems-focused approach to digital platform regulation. So this put in place a number of basic online safety expectations about what digital platforms should do to make their platforms safer for people, right, and reduce exposure to harmful content. And again, expanded the range of areas where protections were applied. It also led to, it's a co-regulatory scheme, which is a very common approach, and the main approach that Australia is taking towards digital platform regulation, which is kind of modelled on the Broadcasting Services Act, which is co-regulatory. By co-regulatory, I mean that there's a regulator who has powers to enforce industry codes. So the industry is the one that develops the codes and sets the rules, if you like. But the regulator needs to be satisfied that those codes are going to do the job that they're designed to do. And then the regulator has powers to enforce those of one sort or another. So the Broadcasting Services Act has been heavily criticised for not giving enough powers to the Australian Communications and Media Authority. They either have very weak powers and then nothing in the middle, and then they can move to imposing licence conditions and abolishing the licenses of different broadcasters, and not much in between. So mostly they stay over here, right? And they don't move to that to the more onerous penalties. So the Online Safety Act has that same sort of setup where there's the e-safety commissioner, who asks industry of different sectors to develop codes, and different sectors develop different codes. So search engines, social media platforms, and so on, app stores, all these different kinds of platform have a different code that helps them tailor the obligations to their particular industry sector and the different nature of the different platforms. Right. That said, that all seems well and dandy, but again, the Act and the Commissioner have been heavily criticised. The Commissioner not so much for failing to act, as in the case of ACMA, the Communications Authority, but acting too much. Right. So there's concerns here, particularly over freedom of expression, and also the regulatory burden that the Commissioner is placing on digital platforms. Obviously, those complaints come mostly from digital platforms, right? And complaints about freedom of expression tend to come from certain political sectors, most notably the right. All right, so in 2024, there was a review of the Online Safety Act, which was actually brought forward a year. And because it was perceived that there were problems with how it was operating, as I just outlined. And this was an independent statutory review conducted by a former commissioner of the Australian Competition and Consumer Commission. And I'll speak about them. They're big players in this space. And that review, the final report, recommended that a stronger move towards systems-based regulation with a focus on platform systems rather than on content. So one of the problems of the Online Safety Act being that its scope is defined by various kinds of content. Now, it kind of works for illegal content, but once you move into legal but harmful content, you start to run into these problems. So the aim there is to incentivize platforms to improve their systems, including through algorithmic design and things like that. And this is a common theme in findings of various inquiries and recommendations from academia and from civil society. But we're not seeing much movement towards that. I mean, the government has said that they kind of support that approach, but they haven't done very much yet to move towards that. And so, one aspect of that is that the final report of the Online Safety Act review, as it says there, came out in October 2024. Well, it was given to the government in October 2024, but it was not published until a third of the way through 2025. And the only thing that we heard within that time was that the government would move towards a statutory duty of care, similar to what you see in the UK model. But as was originally proposed in the UK, is a single duty of care for online platforms to kind of set the basis for incentivizing platforms to improve their services. The UK then moved towards multiple duties of care, which again has subjected it to quite a lot of criticism in terms of its complexity. In November 2024 as well, the government announced it would introduce a social media ban for children under the age of 16. This was kind of a surprise. And it really kind of runs against that model, that I said that the government was moving towards, focusing on the improvement of platform systems, right? So everyone had been recommending, including us at CMT, that, instead of kind of taking away the capacity of children to engage online, and placing obligations on platforms to prevent access, which is what this social media ban does. Platforms should be incentivized to improve their services across the board, right? So to make it safer for everybody, not just children, and with a bit more flexibility built in that you if your platform is particularly targeted at children, like YouTube Kids, for example, then obviously, there should be stronger requirements for online safety on such a platform. If it's mostly used by adults, like LinkedIn, for example, then your requirements would not be so onerous. And platforms, if you require them to undertake due diligence assessments, for example, then this can become apparent through that process. And then obligations are tailored to the particular level of risk that you see there. Instead, the government decided to impose a ban. And the reason for that was a media campaign, in particular by the Rupert Murdoch News Corp media, which is the right-wing media in Australia, which has a very large share of newspaper ownership. And on the back of also a book about mental harms to children from social media by Jonathan Haidt, the American psychologist. And this, sort of bubbled up and really came from nowhere. And the way I read it is in order to avoid appearing weak, the government went ahead with the ban. But really, and when I say that the Murdoch media pushed the ban, I don't think it's, I think it was a little bit disingenuous in that their relationship with digital platforms is very fraught, right? As a news media company, obviously all the advertising money from news media has gone to digital platforms, and we'll look at some other areas where this has come in, including the News Media Bargaining Code, which I'll explain about that in a minute. All right. Okay, so just a few more details on the Online Safety Act and how it operates. There's a two-tier system in terms of content. So Class 1 content is illegal content. Class 2 is legal but harmful. There's a whole range of enforcement powers that the e-Safety Commissioner has, much more fine-grained than the Communications and Media Authority. But that said, so the Commissioner, just by the name, you can see that, right? So the Communications and Media Authority is a kind of board structure, right, where there's a number of members of the authority and they have a consensual process about how to regulate. The e-Safety Commissioner is a sole authority, if you like. All right, so some interesting areas where the e-Safety's powers have been challenged. So in April last year, there were two stabbings in very close timing. I think one week after the other, maybe even less than 1 week. So the first one was in a shopping mall in Bondi in Sydney, a famous beach area in Sydney, and this led to a whole range of spreading of misinformation and that kind of thing. That is an interesting case study, but it's not the one that concerns us here. So the second one was a stabbing in a church in Sydney's west. And again, that was live streamed by the perpetrator. And so it was actually a teenager went in and stabbed the priest in the church. It was a very small church, popular with a certain Middle Eastern community, but Christian community. And okay, so this was broadcast live. So the Commissioner used the powers under the Abhorrent Violent Materials regulations that I talked about before to order the takedown of that content on X, okay, or formerly known as Twitter. And not only, so X complied with the request insofar as that content was accessible from Australia or from within Australia. But the e-Safety Commissioner actually asked for the content to be taken down worldwide, and X refused. And the argument being that, well, you can just use a VPN to appear to be from somewhere else. And this went to the federal court, and X actually won that case. So establishing jurisdictional limits on the commissioner's powers, which, I think is not an unreasonable decision. So that's an example of where people perceive the e-safety commissioner to be, pushing the boundaries of her regulatory powers. And another one was that just under the information gathering requirements, obligations, and powers of the commissioner. So the commissioner asked X to explain what it was doing to prevent access to child sexual abuse material and to combat child sexual exploitation on its platform. And again, X challenged the commissioner's request or order, really. And in this case, the federal court found that X was required to comply. And that was just passed a couple of months ago. That decision was made a couple of months ago. All right, that's online safety. I'm happy to take questions as we go if that's easier, or leave them till the end.
You need the questions at
the
end.
Okay, sure. All right, so in terms of competition and consumer law, and then tangentially privacy and defamation reforms relating to digital platforms, a lot of this, as the misinformation regulation that we'll look at, came out of the digital platforms inquiry, which ran from 2017 to 2019. Final report is appearing in June. And that was the government asked the Australian Competition and Consumer Commission, so that's the competition regulator, essentially, to investigate the effect of digital platforms on public interest news and journalism. That was the main focus of the inquiry, but it expanded. I guess they felt that they couldn't really make any findings relating to news and journalism that didn't encompass a whole range of other problems that you see on digital platforms, right? Including data privacy and misinformation and so on. They didn't look at the online safety elements because they were dealt with elsewhere. And that the digital platforms inquiry made a whole range of recommendations, including a news media bargaining code, right? Which you were saying that you were looking at that the other day as well in terms of how it applies. So that inspired some attempts to regulate the relationship between digital platforms and news companies in other jurisdictions, including Canada and New Zealand. And so the News Media Bargaining Code was established in 2021. Originally, it was intended to be a co-regulatory code, right, where the platforms would set the rules that would govern their relationships with news media companies. And the real point here is about revenue sharing, right? So the fact that all the advertising money has gone to digital platforms, and news media companies are in this, slow or not so slow decline, over the last 15 years or more. And they were unable to establish a co-regulatory code. So they actually had to move towards a direct regulatory code or mandatory code. And so that was enacted in March 2021. And what it did was the Treasurer would designate digital platforms to which the code applied. And really their targets were Meta and Google, because they dominate the advertising market. And it would essentially force them to bargain with news media companies and come to an agreement about how much news content is worth to digital platforms, right? And digital platforms argued that Well, our services are of benefit to news media companies as well, right? So in the Google search, the content is surfaced, your news content is surfaced. People click on the link, follow the link to your news website, where you can use your own advertising, of course, generally Google advertising, but you can use your own advertising to earn revenue. And similarly with, Meta's products like Facebook or Instagram, that you can post your news. It gets sent to people's news feeds. They can click on that and then move out of Facebook and go to the news website. But the ACCC, the Competition Consumer Commission, found that it was an unequal bargaining landscape, right? So that news companies essentially have to use Google and have to use social media to get their news out to consumers, right? That's just how the market operates now. But digital platforms don't need to host any particular news company's news, right? They could host this company's news and not that company's news and whatnot, right? And plus, obviously, there's all the other content that they surface that they get advertising income from. So that kind of uneven bargaining relationship was what the ACCC was trying to undermine with this news media bargaining code. Just before it was enacted, Meta actually pulled news from Facebook, I think from Instagram, I'm not sure, but it certainly pulled news from Facebook. And so Australians could not access news on Facebook at all. They also, whatever they, filters they used, also captured a range of other non-news information, like the Rural Fire Service, for example, the Bureau of Meteorology, so you couldn't get weather, you couldn't get warnings about bushfires, which you may know in Australia can be very bad. And, some people speculate that this was deliberate on the part of Meta. So this is what led to it actually led to the inclusion of a clause that required the Treasurer to make an assessment of the market power of digital platforms before designating them. And so, they obtained this concession in this way. Canada, when they enacted their Online News Act, found, introduced a range of other measures that helped to overcome some of the weaknesses in Australia's code. Now, what's happened is that essentially the code is ineffective, right? So the Treasurer has not designated either Meta or Google or any other platform. Some deals were made, but Facebook has declined to renew any of those deals, and Google has also said that it won't renew any deals. So the deals made were worth about 350 million Australian dollars in the end over 2 years, but that appears to be the end of it. The government has just announced that it's going to introduce another measure, an incentive, which is in the form of a levy that all digital platforms will have to pay, but that can be offset against any money that they give to news companies or through deals that they make. All right, so in 2024, also issuing from the platforms inquiry, we got stage 2 defamation reforms, which were about platform liability, essentially clarifying that platforms are not liable for, or a small range of platforms are not liable for third-party content, in particular search engines, ISPs, and so on. And it also introduced a defence for content-based platforms like social media of innocent dissemination. Okay, so they could still be sued for defamation, but they have a defence available to them. The Privacy Act reforms, the Digital Platforms Inquiry recommended a range of Privacy Act reforms, including an individual right of action, which we never had before in Australia, and a statutory tort for serious invasions of privacy. So actually our privacy protections are pretty weak in Australia, and this is, I guess, hopefully just a first step towards greater protections for privacy. It also clarified that there are some protections that apply to personal information. You have to obtain explicit consent now, and personal information also includes things like metadata. In February this year, the government introduced a scams prevention framework, deepfake scams and other kinds of scams on social media. And running in the background from 2020 until June this year was the Digital Platform Services Inquiry, which was kind of, so when the government responded to the original Digital Platforms Inquiry, they kind of shifted most of the competition actions, legislative development and so on, to this new inquiry, which ran for 5 years, looking at different areas like app stores and messaging platforms, things. And that reported in June this year. And again, that emphasised the need to move towards, coherent legislation that regulates platforms across the board, not focusing on these particular narrow areas of content, especially, and the need to focus on platform systems to improve the information environment and to protect consumers and small businesses. All right, in the area of information integrity, misinformation, and so on, again, everything here kind of fell out of that Digital Platforms Inquiry in 2019. And the government actually moved reasonably quickly on this one, which was a bit of a surprise, particularly it was a centre-right government at the time. But they asked industry to develop a voluntary code of practice on disinformation and misinformation. And that was published in February 2021 and, garnered quite a few signatories, Twitter at the time, Meta, Google, TikTok, and so on. But it's a voluntary code, right? And so we'll look in a moment at the problems with that. ACMA, the Communications and Media Authority, reported to government saying you've got to move towards a more, onerous system, co-regulation. The platforms responded with a revised code, which, kind of stepped out the obligations in more detail, which is good. It was a good improvement, particularly transparency and reporting obligations. But then the government indicated that it would move. So it accepted ACMA's recommendation and published a draft combating disinformation and misinformation bill in June 2023. And this was met with quite a lot of public criticism, including, again, from the Murdoch media, including also from the opposition. So in between these two moments, so the original code and the draft bill, there'd been a change in government. And so the party that had been in power originally when the code was introduced was now in opposition, and they decided to oppose the bill, even though they were the ones who said that they were going to introduce it. Anyway, so the government went away, and more than a year later introduced a revised bill into Parliament, which did fix some of the problems with the original bill. But the bill actually, again, met with, despite these improvements, met with a great deal of criticism. It received over 20,000 comments on the online feedback system, and 2,000 substantial submissions. So extraordinary number for any piece of legislation, really, certainly in Australia. And the bill failed in the Senate when they realised they were not going to get the support either of the government or the minor parties, of which they have quite a bit of power in the Senate. So the Greens didn't support it. The Independents didn't support it either. And what I'm going to do is talk in a bit more detail about that bill and what is wrong with it and what I think misinformation regulation needs to look like and where the government should go next. So with that, if you like, as the background and a kind of, descriptive or explanatory excursus into what it looks like in Australia, and the next part of the presentation is a bit more normative. All right. So, all right. So I want to start with, and I don't know if you sent the paper. Did you send the paper?
Yes.
Yeah. Okay. So if you've read the paper, you'll be familiar with these stories.
Share with the group that I don't know if everybody was.
Yeah, sure.
I will see the paper.
Okay. Well, I'll spell it out. So what I want to do here is look at the ways in which the current system has a kind of vacuum of accountability for digital platforms, right, in particular areas. Mainly because it's a voluntary code, but not only because of that. All right, so the first one was in 2023. Australia had a referendum to amend the constitution to create an Indigenous voice to Parliament. Okay, when the Australian Aboriginal and Torres Strait Islander people would have a permanent body on which they could use to advise the government, policy, legislation, regulators on matters that affect them as Indigenous people. It had been quite a long process to get to that point, involving lots of consultation, and had been developed by Indigenous people themselves, the proposal. And there were other parts of the proposal, including a treaty. So Australia's never signed a treaty with its Indigenous people, and is a kind of outlier in that respect. Australia still has, despite its own self-image, still has some quite deep-seated racism towards its Indigenous people. And a lot of that is systemic as well, right? So you see it in kind of the police treatment, discrimination in police treatment, discrimination in court treatment. I think 30%. So the Indigenous population in Australia, I think, is roughly 4 or 5% of the population. The incarcerated population in prison is 30% Indigenous. So that gives you an indication of the problem. All right. So anyway, so we're in the midst of this referendum. It ended up being opposed by the opposition again, like the misinformation bill later on. And yeah, it was quite a fraught political campaign, I guess, when it could have been something else. All right, so during this referendum, X actually removed the ability of Australians to report misinformation on its platform. Again, this was an obligation that is under the voluntary code. Okay, so so Section 5.11 of the misinformation code requires there to be a mechanism for users to report misinformation. What happens after that is a lot vaguer, right? The obligations are not particularly onerous, but they need to have some way of people making a complaint. But X actually turned this off in the midst of this politically fraught campaign. On the 5th of October 2023, a civil society body called Reset made a complaint to the Code Compliance Committee. X failed to attend the committee meeting. They said they were going to go. They just failed to attend, offered no explanation, and the committee decided to eject them from the code. You might think, okay, great. There's some enforcement action there, but of course there's no real consequences because it's a voluntary code, right? So there's no fines that they're required to pay. There's no civil penalties of any order. There's no consequences for the directors of the company or anything. So really, the only damage is reputational, and Elon Musk at that time has already made quite clear that that's not the sort of reputation that he wanted to cultivate. Okay, so that's one example of where a digital platform there's an attempt to make them accountable under the voluntary code, but there's no real mechanisms of accountability. So the voluntary system doesn't provide accountability. Another example is during the COVID pandemic, The Home Affairs Department in Australia referred over 4,000 instances of misinformation to digital platforms, 2,702 of which were removed from those platforms. But the referrals were not made under any law. And the government argued that, and this was discussed in Parliament, in a number of cases, including surrounding the misinformation bill. And the government argued that, look, it was a referral, not an order. So it wasn't a takedown order. They just said, look, here's some content which appears to be in violation of your terms of service. And this is a number of different platforms, Meta, X, and so on, Twitter at that time. And then it was the platform's decision whether to take that down or not, right? So the discretion lay with the platforms. But, it's important to realise that the government has a kind of, soft power that's operating here, right? And there's an imposition on the free expression of users, whether or not it's made under a takedown order or it's a referral from the government. So if you're thinking about protecting the freedom of expression as a freedom of expression of users, then the action is the same. And in terms in which, so the UN Human Rights Council, for example, has, and the Special Rapporteur on Freedom of Expression and Opinion has argued in a number of papers, a number of reports that, as established under international law, that any restrictions on freedom of expression need to be made under law. So the government was effectively delegating its duty to protect freedom of expression to the platforms, saying, you deal with it. We're just letting you know. All right, so we saw that platforms were not accountable for providing mechanisms to users to report misinformation. The government was not accountable for the requests or referrals that it made to platforms, and platforms were not accountable for what they did on the basis of those requests. And this is an interesting accountability void here, which results from restrictions in the scope of the code, voluntary code. So the code excludes professional news from its scope, right? And the argument being that news companies are already subject to their own codes of practice, voluntary codes in the case of newspapers, co-regulatory codes in the case of broadcasters. And so that the argument was that they should not be included in the code, in the misinformation code. But this seems reasonable, but what it does is means that platforms are not accountable for what they do with news content. Right? So this case in 2021, Google actually suspended Sky News, which is a Murdoch-run right-wing news channel, at least partly, Sky After Dark, it's called, and kind of, it's very similar to Fox News in the States. And it's most popular on YouTube, on its YouTube channels. It does broadcast on TV, but its reach is not that large. It's on subscription television, but it has viewers from all around the world on its YouTube channel. All right, so Google suspended Sky News for breaching its misinformation policies, COVID misinformation policies, specifically during the pandemic, and ordered the takedown, or actually just took down a few videos that Sky had posted. All right, so the point here is that even if you think that the videos that Sky put on YouTube were misinformation, right, and breached the misinformation policies of YouTube, that they shouldn't be there, that they shouldn't be allowed to promulgate this sort of misinformation. Even if you think that, the point here is that Sky had no recourse under the code to dispute what Google did, right, to dispute their actions. if they're included in the code, right, then there would be mechanisms established under the code for them to dispute Google's actions. So whether you agree with Sky News or not, or like what they do, I certainly don't. It's important that everybody has recourse, right, who's putting content on a digital platform, that everybody has recourse when the platform decides to take that down. There should be some kind of complaints mechanism, dispute resolution, and so on. More specifically, you should be able to escalate that dispute, take it to an independent ombudsman, for example. But because professional news is excluded, they actually have no recourse. This same problem, as you'll see, extends to the proposed legislation. All right, so I'll obviously skip through this, but the three important elements that we articulate in the paper of accountability. What does that mean? It means that you assign responsibility appropriately, so you can specify who is responsible for what. Right. So what should digital platforms be responsible for? Right. And the whole kind of debate about platform liability and intermediary liability hangs on this question, right? Should platforms be held responsible for what third parties put on the platform, or should they not? And where do you draw that line? Once you've assigned responsibility appropriately, then the responsible party needs to be answerable for their conduct with respect to those responsibilities. Right? And thirdly, you need some kind of enforceability, some means of making sure that that kind of answerability and responsibility is enforceable, preferably by the people that are affected by the platform's conduct. If we need to, I don't know how far we're. Oh, good. Okay. I can't see the time. That's all. All right. So, what do we think that digital platforms should be accountable for? On the one hand, they need to be accountable for the impacts on human rights, and this I think kind of creates the fundamental problem about regulating digital platforms with respect to misinformation. Right, is that misinformation impacts rights, okay, in terms of people's physical safety, their ability to participate in elections and other political matters, discrimination, and freedom of opinion. But content moderation from platforms or from government obviously also impacts rights, okay, and it restricts the freedom of expression of users. Now, traditionally, freedom of expression, international law focuses on the power of states to restrict expression, right? And the only obligations that are imposed on private businesses horizontally through regulation and legislation that states pass. Now, there's the United Nations Business and Human Rights principles, and they kind of impose a kind of sense of responsibility, if you like. There's also a few other voluntary schemes that digital platforms have signed up to that, say, yes, we will accept responsibility for these things. We will endeavour to protect human rights, including freedom of expression, and so on. But really, the enforceability is not there unless government enacts legislation to make platforms accountable. Right? Otherwise, as we saw, you can have any kind of voluntary scheme, but if it's not enforceable, then there's no real consequences for platforms apart from reputational damage. Platforms should also be accountable for impacts on democratic society and the public sphere. And this is a bit more nebulous and a bit more open to debate, right? And this is where misinformation often comes in. People talk about chronic harms. So you have acute harms, as we saw, the impact on individual rights, discrimination against individuals, hate speech, that kind of thing. But there's this sense that the information environment, the online information environment, is gradually eroding the public sphere, right? Undermining public trust, enabling exploitation by bad actors, people spreading disinformation, foreign interference from foreign states, and that kind of thing. And yeah, it's a bit harder to put your finger on what these harms consist in, but everyone can see that it's occurring, right? I mean, that's the main thing. It's very hard to quantify. So in that sense, it's also hard to impose obligations on platforms that are based on a kind of assessment of harm or damage that's actually occurred. And that's why regulation needs to move towards a kind of risk-based approach and a kind of systems-focused approach, right, where platforms are encouraged to undertake due diligence assessments of the risks that arise on the platforms, including risks to democratic society and the public sphere. So, and this might be looking at how your algorithms are programmed to promote engagement, rather than civil discourse, for example. And also how news is distributed on your platform. So platforms have tremendous control over the distribution of news, right? News companies, if you like, they put their news on Facebook or TikTok, whatever it is, and then it's up to the algorithm who that gets distributed to. All of these features of platforms, have a large effect on what information individuals are exposed to and in what context. Okay, so who should platforms be accountable to is another important question. And traditionally, you can see that the way that obviously regulation works is that essentially the government, of course, the government is, in a democracy, is representing the people, but it's the government that is enforcing accountability on private companies generally, right? So here in the paper, we articulate two ways that accountability can operate, or two principles of accountability. One is the principle of ownership. And this applies, for example, in commercial law, where, the shareholders of a company are the people to whom the company needs to be accountable to, right? And the board is accountable ultimately to the shareholders. Often, that doesn't work as well as we would hope it to, but that's the principle. Similarly, in a democratic regime, it's kind of the principle of ownership that's operating there, in the sense that the people are the sovereign, right? And the government is accountable to the people through elections. Again, doesn't always work as much as we would like it to, but that's the principle. But this doesn't really apply in this case here of private companies, where those who are affected by the actions of the company are not the owners of the company, right? So it's not that our financial interests are threatened by company malpractice or corruption, for example, as in a public company. Rather, it's the general public or individuals as well who are affected by the actions of digital platforms here. And in that sense, platforms need to be made accountable to the public and to the individuals that are affected. Now, obviously, the state has a role to play here in developing the legislation in the first place that makes them accountable and enforcing that legislation. But interesting things come up when we look at expression and content, and I'll talk about those in a minute. So in terms of how platforms should be accountable, we saw that insofar as their actions do affect human rights and impact human rights, then they should be held accountable under the principles of human rights law. And the problem there being that human rights law generally applies to state responsibility and state exercise of power, not to private companies. But states do have an obligation under international law to ensure that citizens' rights are protected from the actions of private companies. And they also have a positive duty to promote rights, which, if we think about in terms of, if we're trying to incentivize platforms to improve the online information environment, then this is something that we can lean on a bit more as well, about states having this kind of positive obligation here to create an environment that promotes human rights, not just to protect against particular violations. All right. Oh, and the other thing is that, human rights law provides a kind of existing history of balancing rights that we can refer to or rely on to a greater or lesser extent when deciding how we should balance the rights, different rights on digital platforms. So, you can say, and digital platforms like to promote freedom of expression, some more than others. X, for example, says Elon Musk says he's an absolutist about freedom of speech. The advantage of, which is more the American approach, but even then there are balances, checks and balances. But in the European approach, more there's this jurisprudence surrounding the balancing of rights, which could be useful. All right, so I've said again and again that there's this movement towards systems-based regulation where we're looking at platform systems, not at content, right? So the misinformation code in Australia, the voluntary code, its scope is determined by content, right? Namely misinformation and disinformation. And then there's various exclusions from that scope. And most digital platform regulation hitherto has worked in this way. The Online Safety Act, again, works in exactly the same way. It says, here's class 1 content, here's class 2 content. This is how it needs to be dealt with by digital platforms. So in order for this kind of regulation to be useful, you need to be able to look at content, assess what it is, right? Determine what kind of content it is. Is it illegal content? Is it lawful but awful? Is it misinformation? Is it false? Is it misleading? Is it disinformation? Is it spread intentionally, right? And these things are very difficult to determine in any normal circumstances. Courts can take a long time to establish facts of the matter, and to expect digital platforms to make these determinations and then for a regulator to assess those is very onerous at the kind of scale that we're looking for. So rather than the other problem is it's an ex post approach, right? So somebody posts content, somebody complains about the content, and then whether it's through the Online Safety Act or whatnot, or a complaints process internal to the platform is asked to take that down. Right? There might be various levels of obligation and enforcement there if they don't do that. So the content is already there. The content might have already done the damage. If we think about the broadcasting of the Christchurch massacre, right, or the stabbing of the priest, the content's already gone viral online, right, and we're trying to address it. Even if it stays later, it's too late, right? And with the replicability of online content, you can make copies all over the place. So it's a kind of, what they call a whack-a-mole approach, where, the content appears again, we order it to be taken down, it's taken down, the content appears again over here, we order it to be taken down. And of course, it requires different digital platforms to be subject to the obligations under legislation to do that. Otherwise, we're just relying on their goodwill to do it, right? So if instead we take an ex-ante approach, we place due diligence requirements on digital platforms to improve their systems, to detect content that's going viral and to dampen the spread of that content, for example. They do that already, but not as much as we would like. And there's a kind of conflicting incentive in digital platforms to promote content that's engaging, right? And that's the content that goes viral, right? I mean, oh wow, live stream in a mosque in Christchurch, great. Let's watch. People are attracted to this content, whether they like it or not after the fact as well, right? I mean, it holds our attention. But it's a kind of derogation of responsibility on the part of platforms to let this content spread in the way that it does. So they understand that they're pushing the limits, but the incentive isn't there to stop them from doing that. But importantly, no matter how much you move towards systems-based regulation, you still come up with the problem that you need to assess content somewhere along the line. Okay, so if you have an illegal content scheme like the Online Safety Act, child sexual abuse material, for example, then someone has to make that assessment, right, that this content is illegal. In Australia's case, it is the regulator makes that first assessment on the basis of a complaint. And of course, there's judicial review, which applies. So the final decision can be made by the court. But it's a whole different story for content that's not illegal, right? So lawful but awful content, misinformation, particularly where there's a danger of unduly restricting freedom of expression here, right? Imagine if every piece of information that was reported online was disputed by the platform or by the poster of the content, and then that goes to the court, for determination. It's just impossible. There's just too much content, too much decision making, at scale for this to happen. There's even too much, for independent fact checkers, for example. So they need to focus on the most critical content, in a particular context, whether it's around an election or a referendum, for example. And, to a large extent, then we need to rely on platform algorithms and what they're doing, and to a kind of escalated process where assessments can be made. But who should be making these determinations, right? That's the real question. Who is the arbiter of truth? So Mark Zuckerberg famously said, I don't think that Facebook should be the arbiter of truth for what people say online. Well, I think he has a point, right? Do we want Facebook to be the arbiter of what is true and what isn't? I don't think so. But, on the other hand, we have governments. So we can empower governments to make those decisions, and that's certainly reasonable in certain contexts, as we saw. We have the regulator in the case of online content with judicial review, so the ultimate decision maker is the court. That's good, but, the political side of government, so the executive government, do we want them making determinations about what is true, what is false, what is misinformation, what isn't? Particularly in, political debate, it gets very fraught. So I really like this quote from Emily Bazelon. So when it comes to the regulation of speech, we're uncomfortable with government doing it. We're uncomfortable with social media or media titans doing it. It's not just a digital platform problem, it's a media problem. But we're also uncomfortable with nobody doing it at all. So we want this to be taken care of. And in fact, a recent survey of Australians showed that there's tremendous support for the government requiring digital platforms to do more about misinformation. It has, upwards of 80% support from the Australian population. There's problems with these surveys, but in any case, people want more to be done. We've seen the kind of harms that can eventuate that governments really have an obligation to step in to prevent, and to improve the information environment to make it possible to be able to participate online in a kind of civil way without things, degrading immediately into hate speech and so on. All right. So what I'm going to do now is just look at how this played out in the bill. So obviously these accountability problems, particularly in the nature of the first example that I looked at, or really only the first example that I looked at, where X was expelled from the voluntary code. There's an obvious accountability gap here. As I said, the Communications and Media Authority issued a report to the government saying, look, there's a problem here. You need to introduce legislation to have what they called a co-regulatory backstop to underpin the code of practice, so to make the code of practice enforceable. So the bill was introduced, as I said, subject to a great deal of public criticism. It was a lot of angry and fraught criticism, but and overblown, I think, but at the same time not without foundation. I think that the way that the bill was designed really undermined this movement towards systems-based regulation that I've been talking about, and which the government has said that they wanted the bill to do, right? They wanted the bill to move towards systems-based regulation, yet some problems in the design of the bill meant that they couldn't really do that, and they were stuck on this kind of ex post content takedown scheme. All right, so what did the bill do? It granted powers to the Communications and Media Authority, ACMA, to enforce the code essentially, and a suite of other powers. That was the main focus of the draft bill, and then the revised bill introduced a range of stronger accountability measures and also introduced some important protections for freedom of expression. So it set transparency and reporting rules for digital platforms. It gave ACMA powers to register industry codes and make standards where codes were inadequate or were not forthcoming from industry or was not satisfied about those codes. And it gave them a range of information gathering and enforcement powers, and a better range than they have under the Broadcasting Services Act. Importantly, it also required platforms to undertake due diligence assessments, including on algorithmic risks. Was quite a new move from the government, and to report on those risks in public reports. And ACMA would then, as the regulator, assess platforms' due diligence assessments, transparency reports, and so on. So that was something else that was added in the revised bill as well, was the some acknowledgement that platforms themselves have an impact on users' freedom of expression. Again, the way that they can take down content, for example. You might, for example, my wife's an artist, and she does some paintings which are inspired by Catholic religious iconography, including these tall conical hats that they often wear in Spain. Right? And to American platforms, they don't look like Catholic penitence hats. They look like the Ku Klux Klan. Yeah. And so her images that she posts, to publicize her art on Instagram were taken down. And the platform's trying to do the right thing, but they nonetheless should be accountable for what they do, right? So if they take down the content, you should be able to put in a complaint, which my wife did, but it's assessed again at an algorithmic level, and there's no recourse often, right? So she had no recourse. So you should be able to escalate the complaint and so on until you're satisfied with the decision by an independent body, for example. Anyway, and so ACMA under the bill would have the power to make rules relating to complaints, for example, to make it obligatory to have a complaints mechanism, but it wasn't obligatory under the bill itself, right? So things like transparency reporting, due diligence assessments were obligatory under the bill, but consumer complaints mechanisms were not. So there were still some weaknesses in that, the particular accountability provisions that were included. But the real problems in accountability came from the way that the scope of the bill was defined. And the scope was defined problematically in terms of the content to which it applied to, right? So already you're running up against this problem of, is it a content-focused regulatory regime or is it a systems-focused regulatory regime? And so the scope was set by the definitions of misinformation and disinformation, which are defined roughly as they're generally defined in various regulatory instruments around the world. Information is unintentionally spread false or misleading information. Disinformation is intentionally spread false or misleading information. So where there's an intention to harm or to deceive, or where it's propagated by bots or troll farms and that kind of thing. All right. So the scope of the bill is defined by these two types of content. It's problematic already because it's very hard to distinguish between misinformation and disinformation in practice, right? How do you establish the intention of a random post on social media? Sometimes you can, sure, but often you can't. The other thing is you can get bad actors infiltrating online groups, for example, spreading disinformation under this definition. And then other users might innocently propagate that misinformation, believing it to be true. So it's a very murky, and complex online ecosystem here. And to try to kind of establish clear definitions which help in the operation of regulation, so help the regulator and help the courts, for example, in making decisions here. You often need, clear definitions. Clear definitions help in the exercise of that power. They're important in kind of, placing checks on the exercise of government power there. But yeah, so the problem is you've already set the scope on the basis of particular type of content. That means other content is not excluded. Other content is excluded from that scope. And if it's excluded from the scope, then you get the same problem that we saw with the Sky News example, right? So again, professional news was excluded from this bill. But what that means is that, again, that digital platforms are not accountable for any actions they take against professional news, right? So even under the bill as it was introduced, Sky News would have had no recourse because its content is not subject to ACMA powers under the bill, right? Or digital platforms, if you like, are not subject to ACMA powers under the bill with respect to professional news. So here there's a real confusion, and we made various submissions on the legislation as it was being introduced, and as is normal, I guess often it's ignored. But there's a real problem here in what the government conceived of what the bill was trying to do. And this led to a lot of the problems with the public reception of the bill as well. So there's a perception that, that was based in a perception that the government was requiring platforms to remove misinformation from their services, right? But that wasn't the purpose of the bill. The purpose of the bill was to make platforms accountable for the removals that they already make under their own terms of service, right? So platforms already remove a range of content, right? And some of that is misinformation, as we saw during the COVID pandemic. That was their own terms of service. I mean, sure, there was a bit of, suggestion from governments that they should do this, right? Which is, again, problematic for the reasons that we went into before. But that's the important thing to realize is that digital platforms already moderate content. That's, in fact, what they do. That's their purpose, right? If they just let all the content that people put on there, be propagated out into the ether, then it wouldn't be a very good experience for their users either, right? Users need the content to be moderated by algorithms so that they see what they're interested in, right? Now, part of that is also what platforms want them to be interested in, right? And that's why they promote, viral content so that you get user engagement so that they can sell advertising clicks and so on. But that's the key thing here is that platforms already take action against user content. What needs to happen is for them to be made accountable for those actions and for governments or the public to guide platforms towards what we think is a reasonable, actions in this respect. What do we think is publicly acceptable for online content to look like or for the information ecosystem to look like? These are obviously very complicated questions, right? But without that kind of accountability that's provided by this sort of legislation, then there's no incentive for platforms to do that beyond the commercial incentive, right? And as we've seen, the commercial incentive often runs up against, the kind of civic incentive, if you like, or lack of civic incentive, but what we want platforms to be, which is a space where we can engage in civil discourse or chat to our friends without being abused or whatever it might be. Right, so that's the problem of scope. An important protection that came in the revised version of the bill was discretion to moderate. So this was kind of left implied in the draft bill in problematic ways, but specific provisions were introduced in the revised bill that was introduced to Parliament. So first of all, that nothing in the rules, codes or standards, codes or standards established by ACMA or established under the bill itself, requires a platform to remove particular content or accounts unless it's disinformation disseminated via inauthentic behaviour. So what does that mean? ACMA can require platforms to clamp down on bots, for example, and the way that bots propagate misinformation, or it can do something about foreign interference, but it can't do anything about misinformation conceived as innocently disseminated information. So, that's an important protection. And the kind of flip side of that is that nothing in the rules, codes or standards could prevent a platform from removing content or accounts. So the discretion lies entirely with platforms to take down content or not to take down content. Right? That's what's established by Clause 67. So this has helped the revised bill move more towards a systems-focused accountability framework, right? So ACMA can't actually make any takedown requests at all. Okay, so that's important in terms of the public reception of the bill. In the end, it was didn't matter. But and then Clause 68 actually also prohibited ACMA from investigating particular content posted by a single end user. So ACMA's assessment powers of what digital platforms were doing couldn't focus on particular content. It could only focus on the general things that platforms were doing, like their due diligence assessments, transparency reporting, and that kind of thing. Still, there's a problem here because the accountability protections in the bill are limited by that, by the scope, right? So platforms are given ultimate discretion. What that really means is that when we go back to that problem of someone needs to be the arbiter of truth, then okay, under the bill, it's platforms who are the arbiter of truth. Well, that's made explicit by these clauses here. So the government again has kind of derogated its responsibility to protect freedom of expression to platforms. A weird kind of I haven't really mentioned this at all, but Australia has no Bill of Rights, no explicit protections for human rights at all. We are signatory to the Human Rights Convention and various other UN conventions to protect rights, but in practice, the protections are very limited. So all legislation that goes through Parliament has to have a human rights assessment, and that means an assessment under international law. But it's kind of a rote process. It doesn't really affect too much what's going on. The only real protection for freedom of expression is an implied freedom of political communication, which was established by the High Court, which is the Australian version of the Supreme Court, in 1992. And was then, subsequently expanded on in various decisions of the High Court. So under Australia's common law system, that sets precedents for what lower courts need to do. It also places obligations on the government and on the judiciary to protect this implied freedom of political communication. So the few things to note about it is it's a negative liberty, not a right. So an individual can't make a claim against government, and certainly not against a private company or violation of rights. Okay, it's really a matter of assessing legislation and law and court decisions and assessing whether they impose a burden on this freedom of political communication. And so these are things like, protest laws, for example, might run up against the implied freedom where they give police too much power to shut down protests. But really it emerged in media freedom cases. All right. Okay, so where does this leave us? Here I talk about in the paper about this disinformation dilemma or misinformation dilemma. That is, on the one hand, you want to maximise platform accountability, right, for all the actions that they take with respect to online content on their services and any harms that result to individuals. And then again, those kind of more nebulous harms, social and political harms that we were talking about. So we want platforms to be accountable for their actions, for the kind of environment that people encounter when they go on the platform and so on. And at the same time, you want to minimise government power over those decisions, right? You don't want the government to have too much power of what platforms are able to do or not, or you run up against that problem of state incursions on or impositions on freedom of expression. So on the one hand, the scope of platform accountability needs to be broad. The scope of government power needs to be narrow. The Australian bill failed on both counts. The reason it failed is because of the scope problem that I talked about before. So the scope of platform accountability and the scope of government power were both defined by the definitions of misinformation and disinformation with those particular exclusions, right? So that means any power that ACMA had extended to the full scope of the content as it was defined and was limited to that scope, right? But many people felt that was too much power for ACMA because, in the way that it might approve codes and standards and, have to assess what is in those codes and standards is a kind of, second-hand way of determining what is acceptable speech online and what isn't. That was the main worry. At the same time, platform accountability is too narrow because it doesn't include anything that's not misinformation and disinformation. Right. So if we go back to that point that I made at the very beginning about the kind of piecemeal regulatory landscape that we have in Australia for digital platforms, you've got the online safety stuff, you've got we would have had the Misinformation, Combating Misinformation Act, and, these other things which all deal with some part of what digital platforms do, some part of the online environment, but not all of it, right? Whereas, in fact, what you really want to move towards is some kind of regulation that makes platforms accountable for everything that they're doing, right? And we keep kind of inching towards it, but backing away, and certainly with the failure of this bill, that's where we're going. The European approach, I won't go into too much detail, but the Digital Services Act, does try to provide that kind of, broad-based accountability framework for digital platforms. The Online Safety Act in the UK is a lot narrower, but as I said, it imposes a duty of care, which encourages a move towards a systems-focused approach. I won't go too much into that. So, so what we propose in the paper is moving towards some kind of participatory model where decisions need to be made about what content is acceptable or not, what counts as misinformation, what is, again, that lawful but awful content that we're trying to moderate, and even to the extent of what platforms should be doing, that the public should have a voice here to inform those processes, right? It shouldn't be left up to government. And in effect, what we're trying to do is move towards a kind of triangular accountability where you have the platforms on one side and the government on the other. And traditional regulation is just horizontal like this, right? So the government's imposing obligations on platforms really because we want to protect freedom of expression from platforms, and we want to protect it from government as well, right? You need to have a third term in the algorithm, if you like, right? So you want a kind of triangular accountability where the public is holding both platforms and governments accountable for how they're making impositions on freedom of expression and other rights. And that's what we're looking for, is moving towards a general accountability framework. So we have the government has said, yes, we're going to move towards a duty of care. But since that announcement, we've had no detail. Nobody knows what that's going to look like and what it's going to look like. So we're kind of at a point now where we need to be doing the work to ensure that whatever the government does is, beneficial, because what we've got so far has often not been beneficial. All right, I think that's, I don't know. Oh, it's not too bad.
No, that's
right.
Well, I'll stop here. And we have a few minutes for the discussion. Questions, please.
So they think that the problem is only a tool of the digital platform, because I feel that